All right, let's talk about something really important if you're involved in a strata property dispute. A powerful tool called an interlocutory order, which comes from Regulation 35. If you've ever had a problem that needed a solution right now, not months down the road, then you're going to want to understand exactly how this works. Picture this. There's a serious water leak coming from the unit above you, and it is causing damage as we speak. Or maybe someone's completely blocking your parking spot, and you just need it sorted out immediately. These are the kinds of urgent, pressing situations where waiting around for a full tribunal hearing, well, it's just not an option, is it? And that is exactly where the interlocutory order steps in. The best way to think of it is like a legal first aid kit. It's a quick, temporary order from the Strata Management Tribunal that's designed to, stop the bleeding. It doesn't decide the whole dispute, who's right or who's wrong in the long run. It just gives you an immediate, temporary fix for that urgent problem while the main case is still moving forward.
So, you've decided you need one of these orders. Your first question is probably, okay, who am I even going to be talking to? Let's break down who actually presides over this specific type of hearing according to the regulation.
Now, for this initial urgent application, you're generally not going to be standing in front of the full tribunal panel. Regulation 35 is pretty clear that the hearing will be before the secretary or a designated officer. And this is done on purpose. It's designed to make the whole process way faster and more accessible for these urgent matters.
And this is a really crucial point. There's an exception built right in. The chairman of the tribunal can actually direct the case to be heard by someone else, like the full tribunal, especially if the situation is really complex. Think of it as a built-in safeguard, just to make sure the right people are hearing the right case.
Okay, so you know who you're meeting with. Now for the big question. How do you actually make your argument? Let's take a look at what the regulation says you're entitled to do during the hearing to prove your case for this urgent order.
So, the regulation gives you some very clear rights here. First, you can adduce evidence. That's just a formal way of saying you can present your proof, whether it's you explaining what happened or even having a witness. Second, you can produce documents. This is your paper trail. We're talking photos, emails, quotes from contractors, any official letters. And third, you can provide records or things. This could be anything from CCTV footage to, the actual damaged item itself.
Now, this is so important to remember. Just because this hearing is faster, don't think for a second that it's just some informal chat. The regulation explicitly says that the formal rules of evidence from the main Strata Management Act still apply here. This makes sure the whole process is fair and that any decision is based on credible, relevant proof.
So you've presented your case, the hearing's over. What happens next? Let's dig into the final stage of this process, the actual order you get in your hand and what it can include.
The final decision is formalized in a specific document, and it's called Form 15. Knowing the name of the form is actually pretty important for your records and for making sure the order is enforced properly. It's the official piece of paper that carries all the weight.
And here is where it gets really interesting. The order isn't just a simple yes or no. This little quote from the regulation is key. It gives the tribunal the power to attach specific terms and conditions, which basically lets them tailor the solution perfectly to your unique situation.
So what does terms and conditions actually mean in the real world? Well, it could be almost anything. For example, they might order your upstairs neighbor to hire a licensed plumber within 48 hours, or they could temporarily stop another party from starting noisy renovations. They could even require an independent inspection to check out the damage, or maybe ask one party to pay a security bond. It's all about creating a practical, immediate fix. So let's pull all this together. The whole interlocutory order process is designed to be two things: swift and flexible. It gets heard by an officer to speed things up, you get to present solid evidence, and the result is a legally binding, customized order that solves your immediate problem. It's an absolutely vital tool for getting justice when time is of the essence. And that brings us to a final thought. Getting this temporary order in your hands is a huge win for your immediate problem, no doubt about it. But remember, it's just the first step. The main dispute, the bigger issue, still needs to be resolved through the full tribunal process. So the question I'll leave you with is this: how are you going to use the stability this order gives you to prepare for that final hearing?